Well, welcome, judges, practitioners and friends. It's such a pleasure to greet you here for the first Selden lecture held in the Banco Court since the pandemic started to confine our lives last year. You're patently very keen to resume the series. There's a fine turn-up in person and there are another 150 registrants on Zoom. Our first venture back to the Banco Court, as it happens, is for a lecture to be delivered tonight by the first judge sworn in this court, Justice David Jackson, who was appointed in October 2012. He is the 113th judge appointed in the court's 160-year history, and he's going to speak tonight about the 11th, Sir Samuel Griffith. We're all apt to feel somewhat inadequate in light of Sir Samuel's industry and achievements. But I'd venture to say at least that Justice Jackson's career at the bar was much more extensive and intensive than Sir Samuel's. More extensive in time because his honour practised for 35 years, 22 years as Queen's Counsel, and almost certainly more intensive given Sir Samuel's diversion to politics. Justice Jackson is a judge of renowned intellect, so it's fitting that he should talk about another judge of great intellect. One of the fascinating things about Griffith is how multifaceted he was and the number of roles he filled as lawyer and politician. There are many aspects of his career which deserve attention. Justice Jackson has chosen to focus on Griffith, the law reformer. His honour may be better placed than most of us to understand the rigours of that task, having been himself chair of the Queensland Law Reform Commission, which, among other things, drafted the report which led to the passage of the Termination of Pregnancy Act. So, without further ado, I'll invite His Honour to present his lecture.
Thank you, Chief Justice, and may I say I'm truly grateful to all of you for attending. Before I get into the lecture, may I say what it is not. This Society's members and guests are well known for producing extraordinary works of original academic scholarship. This lecture isn't one of them. There is, in draft, a more detailed written paper that will be available after some final proofing. And in it, I acknowledge 3 works on Griffith that I've generally relied on. It's a pleasure that a contributor to one of them, Paul Sayer, is here either in person, I haven't seen Paul if he's in the room, or by Zoom, to listen to my modest contribution in comparison to his in-depth work. Griffith is such a well-known legal figure in this state that all Queensland lawyers have some awareness of him, at least that he drafted the criminal code. This slide is a picture of him as Chief Justice of Queensland wearing his medals of knighthood. Hanging from the chain is the Grand Cross, and on his left breast is the Knight Commander's Cross of the Order of St George. The original portrait by Godfrey Rivers, from which the portrait of which this photo is taken, was by Dargy much later, but the original portrait hangs in the gallery outside the court here, and it's worth looking at. Griffith was a successful politician in the young colony that preceded Queensland becoming a state in 1901. He personally drafted and introduced many bills that became acts. On the national stage, he was one of the chief contributors to the progress and drafting of the Australian Constitution. At the first Federal Convention, his redraft of Andrew Inglis Clark's prior draft was the starting point for the work that was done over Easter 1891, mostly on the Queensland Government steam yacht Lucinda at anchorage in the Hawkesbury River near a fresh waterfall. At that idyllic retreat, 3 of the chief contributors hammered out the provisions that led to the final draft of that convention. At the time, Alfred Deakin recognised Griffith's contribution in a couple of short statements. One of them was this: "In every clause, the measure bore the stamp of Sir Samuel's patient and enduring handiwork, his terse, clear style and force of expression." Most Queensland lawyers know little about the extent of Griffith's law reform work beyond the criminal code. Even those who know a little might be surprised to hear him described as audacious, as the title of this lecture claims. As a reforming Liberal Party politician, Griffith's reputation was diminished by his second term as Premier, that saw him battling the rise of the infant Labor and Unionist political movements, notably during the Great Strike of 1891. It also saw him renege on earlier reforms for which he personally was responsible, that were intended to reduce and eliminate the use of Kanaka labour by 1893. But the present question is whether, as a law reformer, Griffith was audacious. The subject of interest is statutory law reform. The shortest way to make the point about the scope of Griffith's law reform work is to focus on a single day, 1 January 1901. It was an auspicious day for the world, for Australia and for Queensland. It was the first day of the 20th century that, according to the New York Times, was welcomed by New York with a tumultuous celebration. For Australia, it was the day of the commencement of the Australian Constitution that federated the former British colonies that became the states of the Commonwealth. This slide shows Centennial Park in Sydney, where 60,000 people, including Griffith, attended to welcome their new country's beginning. For the newborn state of Queensland, there was another celebration attended by Governor Lamington outside the Treasury building. But it was also the day of the commencement of the Criminal Code Queensland and the rules of the Supreme Court 1900. Some of you in this room will remember the 1962 reprints of the Statutes of Queensland. 2 whole volumes of that work were taken up by the Criminal Code for one volume and the rules of the Supreme Court for the other volume, although they were both annotated. Griffith was a fundamental contributor to the drafting of the Constitution, and he was the sole author of the 2 pieces of Queensland legislation, all of which took effect on that single day. At no point was law reform Griffith's occupation. I've already mentioned his role as a politician. As well, from October 1867, he was at the private bar. From May 1876, he was appointed Queen's Counsel. For a long time, he was the leader of the Queensland Bar. While Attorney General, he accepted briefs for and even against the Crown, including in significant criminal cases. From March 1893, Griffith was Chief Justice of Queensland for over 10 years. He sat in a punishing number of cases. His law reform work was carried out in the midst of this extraordinarily busy professional and political life. Let's begin in 1873 with a civil law. The subject was equity, practice and remedies. The Act was the Equity Procedure Act 1873. It's not an act that anyone knows today. Most of its provisions were abrogated by the repealing rules of 1900, and the balance were repealed by other acts, the final section being repealed in 1995. When Griffith moved the bill in the Legislative Assembly, shortly before his 28th birthday as a private member, equity practice was unrecognisable from what we know today. It corresponded more to the proceedings of the fictional case of Jarndyce and Jarndyce, recounted in the opening pages of Charles Dickens' 1852 novel Bleak House. The same judge or judges in the Supreme Court of Queensland administered the separate jurisdictions of common law and equity. Those jurisdictions were kept strictly separate by the expedient of sitting in the different jurisdictions on different days. Bruce Macpherson once mused that Justice Lutwich in equity on Monday, common law on Monday, might have sent a case away to come back before Justice Lutwich in equity on Tuesday. But he was able to ascertain as a fact that in practice, Justice Lutwich was known to have granted common injunctions in equity to restrain proceedings before him at law. When Griffith was admitted to the bar aged 22, the methods of equity were not well known in Queensland. In both civil and criminal matters, and Griffith appeared in both, practitioners were accustomed to common law trials. They were all heard before a jury who gave a verdict or verdicts after seeing and hearing the witnesses' evidence. By contrast, a hearing in equity was conducted on sworn pleadings with pre-trial cross-examination before the registrar, not the trial judge, with the answers recorded in longhand. Equity procedure did not allow for viva voce or oral evidence. There were moves afoot in England that led to the passage in England and Wales of the Revolutionary Judicature Acts of 1873 and 1875. But in 1873, all this lay in the future. Instead, Griffith brought a bill for law reform, drafted by himself before the Legislative Assembly, that became the Equity Procedure Act 1873. His bill, across its 101 clauses, borrowed from the model or drafts that informed the later Judicature Acts, but there was a big reform of his own making in what became Section 1, as the text on the slide shows. It provided in part, in all cases of which any person has an equitable claim or demand, whereof the only relief is sought, is the recovery of a sum of money or damages, as if such claim or demand were enforceable in a court of common law. For an equitable claim of debt or compensation, this innovative section replaced the old equity hearing procedures with common law trial procedures, including the use of a jury and oral evidence for fact-finding. That measure was a peculiar Queensland procedure, as remarked by the High Court in 1953 in Jennings and the Public Curator. The modern general demise of trial by jury has now consigned the innovative reform of its day to history. In the paper, I deal with another innovative act of importance at around the same time for which Griffith was responsible, namely the Insolvency Act 1874. Paul Sayer wrote about this in 2002, and I cite his article in the paper. It remained the insolvency legislation in place for individuals in Queensland until 1928, when replaced by the commencement of the first Commonwealth Bankruptcy Act 1924. From 1874, Griffith's political position changed after the formation of the third McAllister government. Arthur McAllister was a Glaswegian-born solicitor who practiced in Ipswich and Brisbane. Griffith was McAllister's articled clerk between 1863 and 1867. From 3 August 1874, Griffith became Attorney General. From 1876, he was the Minister for Public Instruction, now called the Minister for Education. And from September 1878, he was Minister for Public Works, in both cases until January 1879. There isn't time to deal with the other acts for which Griffith was responsible during this period, but an honourable mention should be made of the State Education Act 1875 that provided for free, secular and compulsory primary school education and laid the foundations for both primary and secondary education of that kind for the future. Griffith had an ongoing interest in education generally. I see Paul Sayer. He was a trustee of the Brisbane Grammar School for a lengthy period of time and a founder and trustee of the Brisbane Girls Grammar School as well. His children attended both schools. At the girls' school, Griffith House is named after him. Griffith became Premier for the first time from 10 November 1883 to 13 June 1888. There were many important law reform questions and other issues during this period, and I mention a number of them in the paper. But I've chosen 2 pieces of legislative law reform for closer mention. The first is the Justices Act 1886. It dealt with criminal proceedings before a magistrate or justices of the peace. There was an original publication of the book with a foreword by Woolcock. Before 1886, the principal statutes in force relating to the powers of justices of the peace were the UK Acts known as Jarvis's Acts and the New South Wales Acts adopting them, as amended. Before 1879, Chief Justice Cockle had undertaken the task of consolidating and simplifying that legislation and prepared more than one draft bill that did not proceed. In 1885, after much revision at the hands of Griffith, who was then Premier, a bill for a consolidated and enlarged proposed Justices Act was introduced. In the following recess of Parliament, the bill was once again carefully revised by Griffith, and the final bill, in 265 clauses, was passed in early 1886. I don't greatly regret there's not time to elaborate further, notwithstanding its importance in 1886, and today the subject matter is not all that lively. But it is notable that since at least the 1970s, there has been time and again reference or consideration of whether the Act should be overhauled and replaced. But as yet, there's no law reform agency in this state who's not daunted by the prospect enough so that they have not done it. The second piece of law reform from this time is the Offenders Probation Act, 1886. It provided a discretionary power for the conditional suspension of a sentence of imprisonment imposed on a first offender for a sentence of less than 3 years. There's no doubt this was a Griffith innovation, being the first of its kind in the Australian colonies, the United Kingdom, or the rest of the British Empire. It was drafted by Griffith after meeting Howard Vincent, an English reformer, who told Griffith about the probation system he'd seen in Massachusetts. Vincent gave Griffith a pamphlet, which during the second reading speech, Griffith acknowledged he'd lost when before he was drafting the bill, and that his bill didn't quite conform to the pamphlet and the system that he'd been told about, but he thought it was good enough anyway. On 13 June 1888, Thomas McIlwraith's National Party won the election and he became Premier again. That election saw Thomas Glassey as the first official Labor candidate elected to the Legislative Assembly for the seat of Bundamba. Griffith accordingly went into opposition as leader of the Liberals. But in 1889, there was another piece of legislation of his making. It was the Defamation Law of Queensland, 1889. Griffith drafted the bill, as he put it, because it would be a very great convenience to codify the law as it is or ought to be. There were three important innovations that can be mentioned. One was to all but abolish the distinction between slander and libel. He used oral defamation rather than the old word. So they were more or less gone as organising concepts. Another was, in Griffith's words, to eliminate the element of malice, express or implied, and to substitute the principle that all defamation must be justified or excused, enumerating the conditions when that defence might be established. And that language, unless justified or excused, is a Griffith theme. It's used later in the code, as many of you will recognise. The third was that truth simpliciter was not protected, although that was the law in England for civil defamations. Griffith successfully advocated that public benefit be retained as an additional required element, as shown on the screen in section 16. And that was the law until the Uniform Defamation Acts came into effect in around 2005. In August 1890, Griffith's Liberal Party went into coalition with McIlwraith's National Party, with Griffith as Premier and McIlwraith as Treasurer. The alliance of the two former adversaries was amusingly called the Griffith, and it was heavily criticised, in particular by a gentleman named Stephen, who wrote a little book about it. But this soon became the time of the great shearers' strike of early 1891 that saw the government take the side of the pastoralists against the striking shearers. For most of the strike, Griffith was in Sydney at the first Federal Convention. He left in February and didn't return until April. The year of 1893 started for the colony with the Great Flood of 1893 in Brisbane. Both the Victoria and Albert bridges went with the flood. The slide shows the broken Victoria Bridge. It wasn't replaced until 1897. The slide also shows the replacement being built. This caused great disruption in Brisbane at the time, although not so much for Griffith. He commuted by carriage between the city and his grand home, Merthyr House, built on the river at New Farm where Merthyr Road runs today. The late 1892 and early 1893 context to Griffith's appointment as Chief Justice of Queensland was nothing short of explosive. Chief Justice Lilly was in the habit of sitting in cases where his son appeared as counsel for one of the parties. He was accused of unfairly deciding in favour of those parties. One attempt at a response was the Justices' Prevention Bill 1890. It would have prevented a judge from sitting in a case where his relative appeared for one of the parties. The Hansard record of the debate shows it was specifically directed at Lilly, but the bill lapsed. Another response was that from 14 April 1892, a judge in chambers was required to adjourn a contested application into open court. However, starting in 1891, Lilly sat in Queensland Investment and Land Mortgage Company in Grimley and others. His son appeared for the plaintiff. In 1892, towards the middle of the year, he made a controversial decision in favour of the plaintiff, rejecting contrary findings of the jury. There was a successful appeal decided in October 1892. In the meantime, amendments had been made to the Supreme Court Act prohibiting the judge who heard the case at first instance from being in the full court that disqualified Lilly, and authorising the appointment of a judge from outside. Justice Windy was brought in from New South Wales so that there could be 3 judges. McElwraith had been one of the unsuccessful defendants at first instance. Incensed by Lilly's decision, McElwraith set about organising the votes in Parliament to remove the judge for misconduct. A few days after the full court's decision, Lilly announced his intention to resign, and it was in those circumstances that Griffith took his place. There's an interesting aside that I'll mention about this time. It's a bit diverting. Not long after Lilly's announcement, the remuneration of the office was increased from £2,500 to £3,500. Such may be the spoils if you are the Premier organising your own appointment as Chief Justice. Equally diverting is that 10 years later, not long before Griffith resigned to become Chief Justice of Australia, the remuneration of the office of Chief Justice of Queensland was reduced again to £2,500. In 1893, soon after appointment as Chief Justice, Griffith undertook to prepare a draft code of criminal law. During the next 4 years, he undertook and completed the task, and he did it unassisted. On 29 October 1897, he presented his draft. The slide shows a picture of one of the pages of that document. You'll see, if you look at it carefully, that it shows section 25 of the draft, which became section 23 of the code, and alongside it the words compare Italian Penal Code section 45 that I'll mention. In 1899, with minor revision, Griffith's draft was enacted as a schedule to the Criminal Code Act 1899. The extent of the influence of the Queensland Criminal Code is not as widely known as it should be. It was summarised in a diagram prepared by Robin O'Regan QC. A copy of the diagram is on the slide. In all, there are 20 jurisdictions whose criminal code was derived from Griffith's code. They include, as a matter of diversion again, Israel. For today's purposes, the question to be asked, however, is can Griffith be described as audacious in drafting the code? As a starting point, a criminal code was not a novel concept in 1897 or even earlier. The French Penal Code of 1810 was an early European example. In the United Kingdom, Jeremy Bentham was a strong advocate, and between 1835 and 1837, the first Law Commission of India, chaired by Thomas Macaulay, drafted a penal code for India that was subsequently enacted in 1860. You had to have the war in between. There were other drafters of potential criminal codes, but the most important was Sir James Fitzjames Stephen, whose draft code as revised was introduced as a bill to the House of Commons in 1880, where it lapsed. Starting in 1893, however, Griffith didn't simply go to these comparators for inspiration. Instead, he prepared his own digest of the statutory laws applying in Queensland, other than imperial statutes, comprising over 1,000 offences, and on 1 June 1896 presented the digest to the Attorney-General as a progress report. Griffith's subsequent drafting of his own code went to subjects and sources not considered in any of the codes I've previously mentioned. In particular, Chapter 5 of the Griffith Code dealt with criminal responsibility, including some excuses. It had no model or precedent in the Indian Code or Stevens Code. Where did the concepts come from? Griffith himself identified the Italian Penal Code 1888, sometimes called the Zanadelli Code, as a source he consulted, for example in the note that I've already shown you. But he also consulted other continental codes. According to the marginal notes, 15 sections were informed by the Italian Penal Code. What became Section 23 of the Criminal Code was one of them, and it relevantly provided, for today's purposes, as drafted by Griffith, a person is not criminally responsible for an act or omission which occurs independently of the exercise of his will, or for an event which occurs by accident. There is no doubt this was an innovation. Was it a good one? Not everyone has thought so, and some of the detractors have highly regarded voices. Let me mention 2 points though. First, some detractors dislike the whole idea of a broad provision negating criminal responsibility for accident. The best known of them was Sir Owen Dixon in 1961 in Valence and the Queen. Second, for a long time there was a division of opinion about the scope of what constituted an act or omission within the meaning of the first limb of the section. As well, there was debate about what constitutes an event that occurs by accident that was related under the second limb. Personally, I beg to differ from the detractors. Dixon's generally expressed disdain for the structure of the criminal code was as set out on the slide. He said, "The difficulty may lie in the use in the introductory part of the code of wide abstract statements of principle about criminal responsibility, framed rather to satisfy the analytical conscience of an Austinian jurist than to tell a judge at criminal trial what he ought to do." I think we can accept that Dixon didn't like Griffith very much. When he retired as Chief Justice of Australia, Dixon said of Griffith that his mind, quote, was a legal mind of Austinian age representing the thoughts and learning of a period which had gone, unquote. That was a repetition of the criticism levelled at Griffith indirectly in the passage from Valence that I've cited. The purpose of Chapter 5 of the Criminal Code was, as Griffith put it, it is never necessary to have recourse to the old doctrine of mens rea. Chief Justice Dixon's disdain was expressed in reference to the Tasmanian equivalent of Section 23, which had slightly different text. But it was not limited to that section. The reader is impliedly invited to consider the treatment of mistake of fact in Section 24 of the Criminal Code in the same way, because the remarks were directed not just to Section 23 or its equivalent, but to the whole concept. In 1937, Justice Dixon, as he then was, dealt with mistake at common law in Thomas and the King. It's set out on the slide, but I'll read it in part. At common law, an honest and reasonable belief in the existence of circumstances which, if true, would make the act for which a prisoner is indicted an innocent act has always been held to be a good defence. This doctrine is deeply embedded in our criminal law. And later on, the matter is one which, since Bentham, has been a commonplace of analytical jurisprudence. I would call that a wide abstract statement of principle. I would accuse Chief Justice Dixon, who unfortunately can't reply, of a little bit of hypocrisy. Section 24, as drafted by Griffith, was as follows. A person who does or omits to do an act under an honest and reasonable but mistaken belief in the existence in any state of things is not criminally responsible for the act or omission to any greater extent than if the real state of things had been such as he believed to exist. The section contained the dual requirements that the relevant mistaken belief must be held both honestly and reasonably, conformably with Justice Dixon's broad statement. Coming back to the second group of criticisms of Section 23, whether the act or omission referred to, let's focus on the act, might include all the physical elements that constituted the offence, and if not, which acts were referred to. After Justice Gibbs' judgment in 1973 in Kopranowski and the Queen, it's a bit difficult to know whether to call it Kopranowski or Kapranowski. It's spelt with a V in the High Court and a W in this court. But after that judgment, I think most of the argument is resolved. There is a debate that remains, however, and it's between the merits of Section 23 and the structure of the Australian Model Criminal Code as reflected in Chapter 2 of the Criminal Code 1995. And I deal with this in the paper. Unfortunately, the definitions are complex enough so that even trying to read them out or use them in a lecture like this is a bit too much. My conclusion is that the tasks of the trial judge in directing the jury, you'll remember that was what Justice Dixon referred to in Valence, and the task of the jury in applying them are more difficult under the relevant provisions of the Commonwealth Code than they are under Section 23. I would suggest that a primary goal of a criminal code is that it should be well understood by a jury and readily capable of reduction into a simple direction to the jury by the trial judge. The structure of the provisions of the Commonwealth Code may better correspond to the pre-existing common law and may also provide a more complete code in the text in the tradition of Bentham than does the Griffith Criminal Code. But the task of the trial judge in directing the jury and of the jury in applying them is more difficult. As to the Penal Code of New York, which was consulted by Griffith, David Dudley Field was a leading member of the commission that produced the New York Code. In 1887, Griffith visited him in the United States. Griffith was probably introduced to Field through Field's daughter, Lady Jeanie Lucinda Musgrave, who was wife of the Governor of Queensland and after whom the Queensland government steam yacht Lucinda was named. The Lucinda was ordered in 1884 by Griffith's government. It was built in Scotland. That there's a paper written about Lucinda by Michael White in his publication. At the time of these events, however, it may not have been quite as an extravagant or unnecessary proposal as we might think now. In those days, there was no rail connection between Brisbane and Sydney. One was only built in the late 1880s, and it involved going via Wallangarra station near Stanthorpe and down through Tenterfield. The coastal rail wasn't built until the 1930s. It was more than 10 hours from Brisbane to Wallangarra, let alone going from there to Sydney. On the Lucinda, though, which had a maximum speed of 12 knots, you could get to Sydney in a little over 2 days. There's no question, coming back to the topic though, that the Criminal Code is a well-drafted statute. That's not to say that some of its language couldn't be modernised so as to be more accessible to modern jurors, or that no deeper criticisms can be made. I mentioned some in the paper, but the obvious one most practitioners and judges know about, of course, is self-defence, which is unnecessarily complicated. But in my view, they're among only a handful of exceptions to the general quality of the original 733 and now 753 sections. I said earlier that alongside his role in law reform while Chief Justice, Griffith sat in a punishing number of cases. Let me colour in the picture a little by giving you some numerical data of his judicial work. The data is incomplete because it's done by reference to the reported judgments only, but it shows 491 reported judgments that can clearly be attributed to Griffith in the 10-year period he was Chief Justice. I analysed the data a little more in the paper, but on average, Griffith published approximately 50 reported judgments per year. And even in today's terms, that's not a bad number. There are differences that make it slightly difficult to compare the work of a current judge to Griffith's day, but you shouldn't forget that he didn't just publish reported judgments or sit in the full court. He sat nisi prius, is the way it was described in those days, both in civil and in crime. He went on circuit reasonably regularly. These things are written about by one of his biographers being Graham, who was originally his associate and might have been expected to know something about the work that Griffith did. I also mentioned earlier the Supreme Court Rules 1900 as a piece of civil law reform initiated and drafted by Griffith, and I deal with two specific innovations in the paper. Largely speaking, Griffith's Rules of 1900 were informed by the 1883 English Rules of the Supreme Court. But again, Graham, who with Wilson published in 1902 an annotated and helpful version of the Queensland Rules of 1900, said that one only had to look at the tables at the front of his book to show the extent of the differences, and they were extensive. As the last instance of Griffith's work as a law reformer, I mentioned the Judiciary Act 1903. On 6 February 1901, Griffith began work on the bill and completed it and the draft rules of the High Court within a few months. On 9 May 1901, the Australian Parliament was opened for the first time in Melbourne, and this is the painting of it by Tom Roberts called The Big Picture. On 5 June 1901, within a month, the bill was brought into the House of Representatives. However, there were a number of contentious questions. They included things like who would be Chief Justice. Griffith had an interest in that. Who was going to pay for what? How much the judges were going to be paid? There was a dispute about that shortly after the court was created. And where the court would sit. And there was an argument about whether it should sit in one place or move as it historically has done on circuit. Eventually, the Act was passed and commenced on 25 August 1903. On 5 October 1903, Griffith was appointed Chief Justice. For today's purposes, I will focus on Section 39 of the Judiciary Act. As drafted by Griffith, it provided, in part as set out in the slide, subsection 1 provided the jurisdiction of the High Court, leaving out some words, shall be exclusive of the jurisdiction of the several courts of the states except as provided in this section. And subsection 2, the several courts of the states shall, leaving out some words, be invested with federal jurisdiction in all matters in which the High Court has original jurisdiction or in which original jurisdiction can be conferred upon it, except, and the sting in the tail was the exceptions. There were a number of them. I'll paraphrase them. First, state courts were invested with federal jurisdiction subject to sections 37 and 38, which I don't need to trouble you about. Second, there was to be no appeal to the Privy Council from a judgment of a state court exercising invested federal jurisdiction under section 39, subsection 2. Third, the appellate role of the High Court on appeal from a state court exercising federal jurisdiction was reinforced. And fourth, the constitution of a state court of summary jurisdiction exercising federal jurisdiction was restricted to authorised appointees. The structure and purpose were pretty clear. The first step in subsection 1 was to exclude the pre-existing concurrent jurisdiction of state courts in any matter where the High Court had or might have jurisdiction that was not already exclusive. The second step was to replace what was taken away as federal jurisdiction, but with conditions including the important condition of no appeal to the Privy Council. And the purpose was to ensure the dominance of the High Court in all matters of federal jurisdiction. The cynics among us might think there was always going to be trouble in excluding the jurisdiction of the Privy Council beyond section 74 of the Constitution. And that's what happened. In 1906, the Privy Council expressed the view that part of section 39 was invalid in a case called Webb and Outram. That did not deter the High Court, led by Griffith. The next year, when a like question came before it in Baxter and the Commission of Taxation, the High Court did not follow the Privy Council. There was an appeal from the High Court's decision, but it was avoided by the underlying particular question of dispute about the operation of the legislation being taken away and the Privy Council refused leave. There was a tilt to the side after Griffith's retirement when the High Court strained against giving section 39 subsection 1 its full effect to exclude state courts of their concurrent state jurisdiction in federal matters, but later High Courts took the opposite view and the vessel was righted. I deal with the particular cases in the paper in some detail. I don't need to trouble you now. But the detractors remained, particularly Professors Cowan and Zines. Another respected commentator, Professor Colin Howard, called the section complicated to the point of incomprehensibility. And in 2001, the Australian Law Reform Commission suggested that the section be amended because a number of the conditions under section 39, subsection 2 were no longer needed. By then, for example, it was anachronistic to have a condition of federal jurisdiction prohibiting appeals to the Privy Council because they went all together with the Australia Act. But in the executive summary to the report, the Commission said what appears on the slide, namely, in the Commission's view, the mechanism by which this is done is needlessly complicated, and the Commission recommends that the section be recast in more simple terms. I sincerely hope that the Commission wasn't saying that Griffith's mechanism of excluding concurrent state jurisdiction under section 39, subsection 1 should be got rid of. Justice Walsh explained the problems of doing that in Felton and Mulligan, which was the decision of the High Court that I earlier described as righting the ship. In 2018, the effect of section 39 was summarised in the High Court as it is accepted today and as set out on the slide. Section 39 of the Judiciary Act excludes the jurisdiction of the state courts where the High Court has original jurisdiction or where original jurisdiction can be conferred on it, and then invests the state courts with that jurisdiction subject to certain conditions and restrictions, as was explained in Baxter and the Commission of Taxation, The result is that the jurisdiction of the state courts is now derived from a new source, with all the incidents of jurisdiction derived from that new source, one of which is an appeal in all cases to the High Court. Of course, in 2018, the Privy Council question was gone. So in the result, Section 39 was effectively drafted in 1901 to achieve the purpose of imposing conditions on the exercise of jurisdiction in matters where state courts were invested with federal jurisdiction. Like it or not, it was an audacious piece of law reform clearly intended to cement the High Court's position at the apex of the Australian judiciary from the beginning of the existence of the Commonwealth. There's more detail in the paper, but I've said enough. I hope to prove to you that the audacity of Griffith as a law reformer, and I leave it to you to make your own decisions. But if you're in any doubt, I suggest you ask this question: who could stand alongside Griffith or above him in the field of statutory law reform? In answering that question, don't forget that your candidate should be focused on single-handed sailors like Griffith. Thank you.
Well, I think we'll all agree that was a very happy return to the Selden lectures. Griffith is a fascinating figure, and he isn't enough celebrated or studied. Listening to Justice Jackson's lecture, and particularly that line of Dixon's about Section 23 being the thinking of a time gone by, words to that effect, it made me wonder who else who's been dead for a century has his work, in the form of the Criminal Code and the Justices Act in this case, consulted and applied by hundreds of people on a daily basis, as happens with Griffith's work in Queensland. I'm not even counting Northern Territory, Tasmania, Western Australia, Papua New Guinea. It's hard to think of anybody else of whom that is true if you put to one side Shakespeare and the Bible. So he is someone who should be much more celebrated and studied than he is. He's remarkable, he's our own, and we haven't paid enough attention to him. Justice Jackson's lecture has gone some way and is an excellent contribution to remedying that state of affairs. So I invite you to thank him again, and on your behalf, I will just give him this small gift.